both you as the chair of this committee and your members for the time you allocated, the understanding you showed, and the patience. Both myself and my client appreciate that, and we express our gratitude. But, Mr. Chairman, in my conclusion, in my summing up, this is what I will say. Mr. Chairman, it's not very unusual in kleptocratic, corrupt, and thieving regimes in this world to see a father who is a president or a prime minister, his wife and children, having their competing hands in the cookie jar of the state and stealing from the public. A classic example you will find in this instance is the former Prime Minister of Malaysia, Najib Razak, who is now going to prison with his wife, Zainab Tekha. Closer to home, there is the instance of the former President of South Africa, Jacob Zuma, and his son, facing all kinds of corruption allegations and investigation. Mr. Chairman, the Governor of Wajir, his wife, are a carbon copy of Najib Razak and Zainab Tenku. But unlike Najib and Zainab, who have been sent to prison, Governor Mohammed and Mama Khaira will probably never be held to account, leave alone going to prison. Mr. Chairman, we are a country that makes excuse for those who steal from the public, admire them in private, and allow them to continue perfecting their modus operandi. And unfortunately, that is Kenya for us. My hope and prayer, Mr. Chairman, is that this committee will call these people to order. Mr. Chairman, misuse of public funds, wasteful expenditure, outright theft, unaccountable expenditure, etc., are all gross violations of the Constitution and many statutes. In poor third world countries like ours, and even in a place that is defined by abject poverty like Wajir, which is one of the poorest countries in Kenya, Governor Mahmoud has a special responsibility, and the standard you hold to him in terms of accountability and transparency are very high. Mr. Chairman, let us not make excuses for the many failures and transgressions of Governor Mahmoud and his government. The buck stops with him. Section 30, subsection 2A to L of the County Government Act makes it very clear that the ultimate responsibility of any failure of the county government falls with the governor. That is the law. Mr. Chairman, during this short and constrained trial, we have, on behalf of the County Assembly of Wajir, discharged our burden of proof and to the required standard in law. We have shown that Governor Mahmoud is in breach of Article 181 of the Constitution, and this committee ought to recommend to the full House his removal from that office. This is the uncontroverted evidence of his breach of both the Constitution and a number of statutes. One, Mr. Chairman, water pans worth 145 million shillings not budgeted for were tendered, awarded, and paid. That is contrary to Section 135 of the Public Finance Act That is not in the budget. It was not provided for. And in my humble submission, Section 135(1) does not save, because 135(1) only comes in if a project that was budgeted, there is a shortfall, and the county government can borrow from other parts of the budget and then subsequently ask for a supplementary budget. That has not happened. Mr. Chairman, that is a gross violation of the law. Secondly, Section 123 of the Public Finance Act requires the county government to develop a plan, submit submit a statement setting out the debt management strategy of a county government for both the medium term and the short term with regard to actual liability and potential liability. Mr. Chairman, this is very important for accountability of public funds. The county government must have this strategy so that it knows what it has, what it can spend, and what it cannot spend. The county government of Wajir willfully failed to implement that. Thirdly, Mr. Chairman, the county government, the witnesses of the county government, the executive arm, admitted this morning that contrary to Section 32, subsection 2K of the County Government Act, the Honorable Governor, for the last 4 years, willfully failed to address and deliver the annual state of county address. Mr. Chairman, again, this is very important. Just like our President delivers the national address, and just like many other county governors deliver that address, it not only gives hopes to the people of a county, but it allows the people to know the vision, the program, the agenda of the governor in terms of what he will do for his people. When Governor Mohammed failed to do that, he was not only contemptuous of his people, but it showed that for the last 4 years, when he could not deliver one address, it shows that he had no agenda, he had no plan, he had no vision, and obviously there was no hope for him to share with his people. Mr. Chairman, that willful breach is a ground for his impeachment and removal. The fourth ground, Mr. Chairman, is that the Wajir County government willfully failed and acted contrary to Rule 167 of the Public Finance Management County Regulation. And again, Mr. Chairman, this was admitted, and failed to create an audit committee, leaving the entire process of auditing and accountability to the docs. Again, this is not just, this is not just an omission. This is a willful strategy so that the county government is not subject to public audit and accountability. 5, Mr. Chairman, the County Budget and Economic Forum, which brings people together, which brings diverse sectors of society, again was not created, again in complete breach of Section 137 of the Public Finance Act. Mr. Chairman, this for me is tragedy because I come from the north, a county that neighbors that. But Mr. Chairman, when you have a county that is the size of Wajir, which is 56,000 square kilometers, it is equal to Central, Nyanza, and Western combined. You have an annual budget of 2.9 billion. And during the tenure of Governor Mohammed Abdi, they spent 12 billion on health. Governor Mohammed found it fit to buy three ambulances. Only 3 ambulances. A budget of 2.9 for a year, or 12 billion for the last 4 years. He bought 3 ambulances for a population of 800,000, 56,000 kilometers. He is not only cruel, but he has no idea about the suffering of his people. That alone should be a ground for his impeachment. Number 7, Mr. Chairman, with a supplementary budget of 194 million shillings and a grant of 38 million from the national government, Wajir does not have a single test machine or kit for COVID. And the oxygen that's used in hospitals comes from a small sub-county in Mandera called El Wak. If this is not callous and cruel, Mr. Chairman, I don't know what is that. Mr. Chairman, during the last days we had all this issue of the Ugali case, as we put it. Mr. Chairman, Wajir County gave a tender for the supply of 42,857 bags or pail of Ugali, at a price of 350 per bale, totaling 149,999,500. The tenders were obtained. There were only 5 responsive tenders. Instead of cancelling pursuant to Section 114C of the Public Procurement that requires at least 8 responsive tenders, the county government proceeded to award in complete disregard of that. I don't think you will find a more expensive pail of ugali than that costed the people of Wajir 3,500. 9. Mr. Chairman, 80% of the tenders awarded by the county government of Wajir is split, so that each tender or each component is about 4 million, with a view to avoid the competitive tendering process, contrary to Section 54(1) of the PPAD. Again, Mr. Chairman, today we had that I showed my admiration because he said it allows the 30 wards to have an equal share, but nothing could be further from the truth. This is what we call doing tendering below the radar, so that the radar of accountability and transparency does not catch you. 10, Mr. Chairman, this morning we had Mr. Ahmed Guhad Umar, County Chief Water Resource Development, award a tender contract worth 39,842 to a company called Fortune Enterprises Limited, in which his sister was a director few years ago. This is contrary to Article 10 of the Constitution. It is in breach of Chapter 6 of the Constitution, and it is something, or it is an issue, the governor must take direct responsibility. When he has his chief officers giving tenders to their relatives or friends, they must be following the example of someone higher in authority. 11, and I'm about to conclude, Mr. Chairman. Governor Mahmoud Abdi abdicated his constitutional duty of exercising executive authority and totally failed in all aspects of the same, as per Section 31 and Section 32 of the County Government Act. 12, Governor Mahmoud Abdi willfully breached Article 10 of the Constitution when he wrongfully exercised the powers he doesn't have under Article 235 of the Constitution and appointed Mr. Jeff Moria. He again committed a similar offense, Mr. Chairman, when he gave Mr. Jeff Moria an extension. That power he does not have under Article 235 of the Constitution. 13, Mr. Chairman, in a complex web involving a number of companies, Governor Mahmoud allowed his wife to take bribes, kickbacks, with a view to award tenders and contracts to a number of persons. Again, took similar bribes and kickbacks when payments were due, and this she did with the tacit support of the governor. Number 14, Mr. Chairman, Governor Mahmoud, His Excellency, allowed to share his executive authority conferred to him by the people of Wajir under Article 1 of the Constitution in exercise of their sovereign mandate, allowed to exercise his executive power with his spouse, Madam Khaira Umar Baalim, in complete contravention of the Constitution. In the process, she participates and exercises effective executive control over the executive arm of the county government. Mr. Chairman, lastly, we have seen the county government admit that when they make requests from the Treasury to pay pending bills, they pay not according to the list they submitted, but as they wish. That breeds corruption, opaqueness, favoritism, and nepotism. And it is in breach, Mr. Chairman, of Article 10 and Chapter 6 of the Constitution. Mr. Chairman, we make one request, that in line with Article 125 of the Constitution, this committee takes the extra step to get the bank's statement of Madam Khaira from KCB or the Ethics and Corruption Commission with a view to establish definitively and once and for all the authenticity of those documents my clients brought to this. Mr. Chairman, my clients, as I said in my opening statements, are MCAs from Garissa, from Wajir. Some of them today could not even know the buildings where they signed affidavits. When you give them the task of authenticating a complex financial transactions undertaken in complete disregard of the law, and tell them that the rules of evidence requires them to bring bank statements, I think that's a little bit unfair for someone who travels from Tarbach, comes here and tries to make a case for the impeachment of this governor. You have that power. Don't shy from it. It's a constitutional obligation you have. Take the extra step, Mr. Chairman. If you prove my client's documents are forgery or fake, I give you my word that they are ready to take the consequence of that. But I think you have an obligation. And I pray that you don't abdicate your duty to do that. It will not take much. Get those bank statements. If you get those bank statements, you will see beyond any doubt the assertions my clients made. With that, Mr. Chairman, I conclude. And thank you again very much, both your committee and yourself, for the time you have given us.
Okay, thank you. I believe senators have no question for you, Sawa. Thank you, Senior Counsel Ahmednasir. Yeah, you did. In fact, you spent less than the time allocated. So I hope Counsel Nyamodi will also borrow leave from Senior Counsel.
We said we are learning from his shining example.
Yes.
Only that we will share our times between Mr. Ndegwa Njiru and the governor.
So each of you will take 10. Ndegwa, I hope you are a good student of Senior Counsel Ahmednasir.
Yes, Chair, I have picked what is necessary and left what will not be essential. Thank you, members of the committee and the Honorable House, for the time you have accorded us to defend and showcase for the Governor of Wajir County. Mr. Chairman, we begin by inviting you to look at our submissions contained in our response and the cases contained there too, insofar as the question of the threshold, the standard of proof, and the nexus between the alleged offenses and the works of the governor. Mr. Chairman, we invite you to look at the case of Governor Wambora, that is case number 37, EKLR. In that case, Mr. Chairman, it placed the burden of proof on the part of the county assembly. When you retire to render yourself, the question then will be whether the county assembly has dispensed off with this burden of proof. Then it also goes further, Mr. Speaker, Chairman, to create the burden of proof and the standard of proof. And it provides that the standard of proof in the case of Governor Wambora, Civil Appeal number 21 of 2014, that the standard of proof is above the balance of probability and not above standard beyond reasonable doubt. It is there in the middle. That means that the question of the threshold of the burden of proof and the standard of proof cannot just be taken on a mere platter of balance of probability. We urge you to look at the case of Muyiwa, Inokuju, and 17 others. It's a Nigerian case. And in that case, the Supreme Court of Nigeria observed that it's not lawful or legitimate exercise of constitutional functions in any jurisdiction just to take impeachment lightly. Impeachment is a serious process with serious political consequences on the person being impeached. Mr. Chairman, it will call until ring bell that evidence was alleged that the First Lady was involved in the processes of the running of the affairs of the governors and the county assembly, the county government. But was there evidence standard? Did it meet the standard of proof? Did it create nexus? The witnesses testified that they went for an informal meeting. How then do you convert an informal meeting and place it squarely within the County Government Act? If they chose to go for the informal meetings, they did it in the frolic of their own. And the governor then cannot be held to account. It has been urged, or this committee has been urged to find the governor culpable for offenses, rather all matters that have not been established beyond the required standard. For example, senior counsel is inviting you to look at the question of the purchase of the ambulances. But the question is, were the ambulances purchased? Are they serving the people of Wajir County? Are we looking at the adequacy of the ambulances or the ability to have the same in possession? What is the quantitative analysis that the County Assembly has given so as to come to a conclusion that the 3 ambulances purchased are not serving effectively the people of Wajir County? Mr. Chairman, you have been invited to look at the issue of expenditure outside the budget. But is there a cure? When you retire and senior counsel, having seriously misconstrued the provisions of section 135, subsection 1, and deliberately omitted to read what this legislator provided, that a conjecture of the word or, and I would read that a county government may spend money that has not been appropriated if the amount appropriated for any purpose under the County Appropriation Act is 1, insufficient. And the one conjecture is, the other one is, or a need has arisen for expenditure for purposes of which no amount has been appropriated by the Act. Why would senior counsel deliberately choose to mislead this House? Why would he deliberately choose not to see this word or? Was it by coincidence that this parliament did that legislation? No. It did this legislation purposively knowing that occasions may arise in a situation like Wajir, a seriously arid and semi-arid locality. And when the county government realizes that the rains are just about to come, there may be not time for such kind of appropriation in a bill. Why? There is urgency to harvest the little water that comes to the people of Wajir. Is it that the county assembly is insensitive of that occurrences? Have they demonstrated to us that they did or they took steps towards addressing that need? Why should the governor be punished for doing what is rightful to the people of Wajir County? Mr. Chairman, evidence was tendered by the county assembly to the effect that there are some alleged accounts which no proof of their origin was tendered. We invite you to look at the case of Philomena Mwilu, that is petition number 295 of 2018. And of most interest is paragraph 226. It provides, having found, however, that the DCI illegally obtained evidence against the petitioner by gaining access to her accounts with this bank through the use of a court order that had no bearing on her accounts, and having found that the DCI thereby misrepresented facts and misused the court order, we have come to the conclusion that the prosecution against the petitioner Philomena Mwilu cannot proceed. Why should this committee admit such kind of documents? Even the county assembly did not have even the courtesy of having the court orders. Is this a case of Philomena Mwilu different from the case that we are facing? Mr. Chairman, we submit no. Mr. Chairman, actions must be taken against this action. why should the county assembly, in its purview of allegedly providing oversight, cross over to personal accounts? How about the right to privacy? Mr. Chairman, as I sum up, there has been a case of Ugali. The question is, was that purchase deserving? Is senior counsel representing the county assembly trying to have a comparative study of commodities purchased in Nairobi and commodities purchased in Wajir? Wajir, which is about 1,000 kilometers, is the county assembly saying that they are not cognizant of the market forces and the fluctuations of prices, of course triggered by different factors, transport and distance being part of it? Can this assembly close its eyes to such kind of factors? Mr. Chairman, does hunger know any border? Does hunger know any law? Does hunger have any scintilla or any iota element of decency? If it had, Mr. Chairman, the defense of necessity available in criminal law would not then have been provided for. Necessity knows no border. Does the senior counsel representing the county assembly want to tell us that procurement procedures supersedes the preservation of human rights and human dignity and the human life, which is the sanctity of human life, and Article 26? Does he want to tell us that we had to compromise the rights of the people so as to comply with the law? Was the law made for the people, or was the people made for the law? Who burdens the other? Who is subject to the other? Does hunger know borders? Pending bills, Mr. Chairman, it was submitted on oath that there is no legislation in this country that governs how pending bills ought to be administered. The question of the pending bill is a policy provision. It's a policy directives. Can a governor be punished for an issue that has not been legislated by this parliament? The question is flagrant breach of the law. Where is that law that deals with the issues of pending bills? Why should the governor carry the burden of an issue that has not been legislated? Mr. Chairman, as I sum up, there is a miserable plea coming from the county assembly. So miserable that you need to now start aiding the county assembly in its work. That you should cease being a jury, that you should cease being arbiters, that you should cease being impartial, cross over and go and start doing the works of investigation. To investigate these banks, why should you help them dispensing their burden of proof? Mr. Chairman, if this committee does that, what shall be our recourse? Who shall be the arbiter of this case? Mr. Chairman, can this committee help to save the sinking ship? This ship is sinking. Mr. Chairman, there is no anchor that can save this ship. The case is miserable. The case is wanting. The case has no legs. There is no any element that has been brought out that can find the governor culpable. Unless the county assembly wants to bring the doctrine of vicarious liability, that the governor is vicarious liable for omissions, and is it every omission or commission that amounts to gross misconduct? Is it every omission or commission that necessitates the gross violation of the Constitution? What did this committee find in the case of Governor Waiguru? The similar facts of address of the county assembly. What was the verdict? Was there an acquittal? Yes. Why should there be a different finding? What did this committee find in the case of Governor Waiguru's impeachment in matters of procurement? What did this committee find in the case of Governor Waiguru in the issue of failure to remit the transport allowances? There was an acquittal. Why was there an acquittal? There was an acquittal because this committee was alive to the fact that it's not every omission or commission that can necessitate an impeachment of the governor. When you retire to render yourself, we invite you to look at section 148 of the PMA Act, section 149, 149A, 123, 109, 7 of the public procurement, sorry, of the PFMA Act. You may also look at section 45 to section 135 and find the governor not culpable. We so plead that we set the bar high as it should be. Much obliged.
Thank you. Thank you.